Hi, Trip Bechert here. SouthFloridaAttorney.com, SouthFloridaAttorney.com update. Um, as an attorney practicing here in South Florida for almost 20 years, I handle a variety of different legal issues, and one of the primary areas of practice in our firm is family law. Family law has four primary areas that are typically addressed by the courts. And when I say four areas, I'm using those numbers in the broadest sense of the word. Um, Family law encompasses a myriad of topics, but the four broad areas typically are the time sharing for children, the child support that a parent will be obligated to pay to the other spouse, equitable distribution, and alimony. And those are typically the four broad areas. Now, each one of those areas has a number of subgroups within them. It's very, very complex, and it's not as easy as one might think. Um, Even though there are four broad areas that usually the courts address. Um, it's typically in the party's best interest to fashion a agreement that the parties can live with rather than having the courts decide for you what is in the best interest of your children and how to divide up your assets and what obligation you are going to be required to pay each month to the other party um, as a result of the dissolution that you're going through. Um, as a litigator for almost 20 years, I can tell you that you always get a better result if you work it out yourselves, as opposed to going to the courthouse and asking the court to do it. In addition to being a litigator, I'm also a Supreme Court certified family law mediator, and I assist parties in fashioning those type of results. The first area is that we addressed here today is a time sharing agreement. A time sharing agreement specifically addresses a number of the issues surrounding the amount of time that a parent will spend with the minor children and the rights, obligations, duties, and responsibilities of the respective parents under that time sharing agreement. Um, as I stated before, the child support guidelines in the state of Florida are calculated specifically by the number of overnights that a parent spends with the minor children. And that encompasses not only the daily uh, number of overnights, but the uh, the number of overnights that you will have for winter break, spring break, holiday break, summer break, um, mom and dad's birthdays, child's birthdays, and teacher work days off, and the like. And when you take all of the days that a child will spend with a specific parent, and you calculate that using the child support guidelines, um, and that is usually derived in its most simplistic form using the two parents' income. You come up with a number that gives you what the respective parties' obligation for child support is. And that's the first monetary number that we usually try to work on because the children are, of course, the most important part of the equation. The second part of the equation is equitable distribution. And equitable distribution is nothing more than a fancy word for how do we divide up our stuff that we accumulated during the marriage. Anything that's accumulated during the course of the marriage is considered a marital asset in Florida and is therefore subject to equitable distribution. And that means that you're supposed to equally divide or divide equitably those assets that were obtained during the marriage. If you inherit property and you do not commingle that inherited property, it's not considered a marital asset for determination of equitable distribution. But there are a number of exceptions to all of the rules, and there are a number of ways in which um, the parties attempt to hide or to get around or to circumvent the rules, which is the reason why you need to have a seasoned litigator or a seasoned mediator reviewing the documents to ensure that what is being done is fair and proper and above board. And the last part of the equation is alimony. It used to be folks referred to the terminology of a party is going to be required to be kept in the lifestyle by which they had become accustomed. And that's typically not the remedy that the courts are looking for today, especially in today's economy. The courts are looking to try to equal the playing field, as they say, and to fashion a remedy that will allow all the parties to live more equally than they would had one party had an advantage over the other. So what they typically do is they adjust based upon the incomes as to what would be fair. If one of the parties is not working but has the ability to work, the courts are going to typically impute or impose a fictitious number that that party could be earning based upon their education, training, and experience, as opposed to allowing them to say that they don't have any income and need more assistance than would be appropriate. So, for example, if a party is never worked in the marriage, but they have a college degree and they have the ability to work, and they're not physically disabled, the court's going to say you're able to go out and get a job in today's market based upon usually expert testimony in the amount of X. What X is will depend upon is a factual issue, but if you can make $30,000 and the experts say you can make $30,000, that's what the judge is going to say that you should be earning, and they're going to adjust that alimony award and the child support award and the other awards based upon that type of a calculation. So there are a number of things that need to be contemplated when addressing each one of the four main categories in a family law dissolution case. And here at southfloridaattorney.com, I can help you address those issues. 954-941-8363, 954-941-8363. Or you can find us on the web at southfloridaattorney.com, and we'll be happy to answer any of your questions and to assist you in any of your family law matters. Please feel free to contact us. Thank you.